So just to introduce our two panelists, I'll start with Adam Goldenberg to my far right. Adam is a trial and appellate lawyer at McCarthy Tétrault here in Toronto and an adjunct professor of law at the University of Toronto. He acts in all manner of commercial disputes, public law matters, and class actions, and has appeared as lead or co-counsel at all levels of court, including the Supreme Court of Canada. He holds a BA from Harvard and received his law degree at Yale, and he was awarded the Meritorious Service Medal by the Governor-General of Canada in 2017. Closer to me, to my right, is Professor Anna Sue, is an assistant professor at the University of Toronto, Faculty of Law, right here. Her research interests are in law and religion, and the law and history of international human rights law. She is the author of Exporting Freedom, Religious Liberty, and American Power. So we're very fortunate to have these two panelists here today, and the two cases, religious freedom cases that we're going to focus on, one from Canada and one from the U.S., from the USA, from below the 49th parallel. Both are similar in terms of kind of the general subject matter that they pertain to which they pertain. Maybe I'll start just by briefly summarizing, setting the table with the Canadian case. Perhaps no surprise, we're going to be focusing on Trinity Western University, on the decisions from last June of the Supreme Court of Canada concerning the proposed law school at Trinity Western University. And I imagine many people here are familiar with the case, but I'll just give a very bare bones summary of this case so we all kind of have working definitions in hand. So Trinity Western University is a private evangelical Christian university in the Metro Vancouver area in British Columbia. And Trinity Western proposed to start a law school a number of years ago now. They got their initial approvals from the provincial government in British Columbia to actually have a degree, but there was the next step of obtaining approvals from the law societies across the country such that their degree program would be accredited so that their graduates, after finishing law school at Trinity, would be able to seek admission to the bar to become licensed lawyers. And there were a lot of kind of machinations and controversy that was raised by Trinity's proposal for a law school, and it all stemmed from one clause, or primarily stemmed from one clause in their code of conduct, which applies a mandatory code of conduct for students, faculty, and staff. That code of conduct reflects Trinity's Christian ethos and identity, and the one clause that I guess lit the fuse, so to speak, for this litigation was a clause that obliged students to abstain from sexual intimacy unless they were married, and marriage being understood in the kind of traditional Christian worldview as marriage between one man and one woman. And so this raised concerns particularly with respect to potential LGBTQ attendees at Trinity Western's law school, whether they would be able to sign this what's called a community covenant. That's the title of the code of conduct, and it raised concerns about whether discriminatory concerns and equality concerns, and that's what led to the dispute. So really a kind of a religious freedom versus kind of equality kind of clash. It's a very complex case with a lot of nuances, but that's the bones or the kind of the essence of the matter. And of the law societies across the country, three law societies ultimately said that they would not accredit Trinity's law school. The Law Society of Upper Canada, as it then was, the Law Society of British Columbia, as it still is, and the Law Society, the Nova Scotia Bar Association, Barristers Society. Ultimately, by the time we got to the Supreme Court of Canada, it was just the disputes in Ontario and BC that were still live. And last June, the Supreme Court ruled in kind of balancing the religious freedom concerns versus the equality concerns, found that the decisions of the British Columbia and Ontario bar associations to be reasonable, to be a proportionate balance between religious freedom on the side of Trinity and the furtherance of the objective of these law societies, their legislated objective, the objective that resides within their enabling statutes to further the public interest and to administer the legal profession in the public interest. So the court found that that was a reasonable balance owing to things such as equality of access to the profession, diversity within the bar, and the potential harm to LGBTQ students were they to attend Trinity Western, given what it would mean to sign that code of conduct and to abide by it. So there's a lot more to that case, and I'm sure our speakers will add nuance to it as they speak about it, but that's the essence of Trinity Western. Very quickly, I'll just go south of the border. This case is a lot more straightforward, I think, in terms of the facts. It's called Masterpiece Cakeshop. It was also decided in June. June was a big month for religious freedom by the U.S. Supreme Court. And it dealt with a baker in Colorado named Jack Phillips, who in 2012 refused to bake a wedding cake for a gay couple. And that refusal led to proceedings under Colorado's anti-discrimination legislation, and he went all the way to the Supreme Court. He was arguing basically that his religious freedom and freedom of expression should permit him to not have to basically get an exemption from that anti-discrimination statute. Ultimately, the case wasn't decided on the grounds of how those various rights and statutes interact. The Supreme Court of the United States ultimately ruled in favor of Jack Phillips on the basis that the initial decision maker, the Colorado Civil Rights Commission, had exhibited overt, on-the-record hostility towards him, even comparing his views, his religious beliefs concerning marriage to being a defense akin to, in one way or the other, to a defense of slavery or even to the Holocaust. So there were some pretty, as the court put it, some hostility that was quite obvious, and that led the court, to the majority at least, to hold that Mr. Phillips had not been afforded a neutral decision maker. As I'm sure our panelists, or they may get to, there is another case that's on the horizon, which concerns a florist instead of a baker, and that one may provide an opportunity for the merits of that kind of an issue to be dealt with by the Supreme Court at some point. Thank you for bearing with me. I know that I think it's important to have the table set, so to speak, and with that I'm going to hand it over to our panelists, and I think, Anna, you're going to start. So.
Good morning. Good morning, everyone. I'm really happy to be invited here and to talk about this case. Thank you, Brian, for summarizing the whole case, so I don't have to. I guess I'll start my remarks by saying that I'll say something about what I think about the ultimate decision between this clash between religious freedom and equality in the Trinity Western decision, but I just wanted to emphasize that I think I was invited here because I was supposed to be against the decision, but my main beef with the decision is basically targeted towards how the Supreme Court characterized the freedom of religion issue in that case, and not necessarily the final result, right? So as a matter of legal doctrine, this Trinity Western decision follows that, frankly, I would say that very deplorable decision in the Tunaha versus British Columbia case in 2017, which involved a religious freedom claim by an indigenous community. And so following that precedent, here in the Trinity Western case, I thought the Supreme Court characterized religion in such an impoverished manner. Because on the one hand, the majority opinion goes so far to acknowledge that the ability of religious believers to come together and create cohesive communities of belief and practice is an important aspect of religious freedom under Section 2, and that there was no doubt that evangelical Christians believed that studying in a religious environment gave distinct spiritual benefits. But then, at the second part of the Section 2A analysis, which is whether the infringement or the interference was substantial or non-trivial, the court held that this mandatory covenant that Brian described earlier is not absolutely required to study law in a Christian environment, because in any case, the Christians remain free to act in accordance with their beliefs. And so you can already see what is the problem here, right? On the one hand, who's to say what is or what is not preferred for a religious community? Certainly not the court, or that a covenant is really required for somebody to be able to study in a Christian environment. I understand it's a difficult issue, and maybe this is the reason why things go up to the Supreme Court in the first place, but it's really up to the Supreme Court to convey the impression that it has really engaged with these issues thoughtfully, and which I thought it did in this case. Now, there's also a variety of claims under this. Obviously, the main act is whether religious freedom can be used and is excuse, according to some people, to sanction some type of discrimination. I have some few thoughts on it, and I'm really looking forward to the questions and the Q&A that we'll have in the later after we're done with our presentations. So there's a variety of claims under this religious freedom versus equality category, and I just want to give my very brief 2 cents, and then perhaps we can talk about it much later. But again, I just wanted to emphasize that the Supreme Court could have arrived at the same result without having to go through that problematic analysis. And it matters because, one, it sends a very problematic message to the religious believers, religious people here in Canada. And second, it matters because then it's very bad law to begin with, to work with for lawyers going forward, right? And so the court's job is really is very important in sending that message. So one of the first things that people say when they hear about this case is that, one of the arguments that was advanced was that religious law schools would not be able to train students who would become lawyers much later on, and then later on they'll become lawyers that will not be respectful of difference or diversity. They will be discriminatory in their practice. But I think the first Trinity Western decision already answers this question in the sense that, absent any sort of empirical evidence, I mean, it's really hard to say that once you're trained in this particular environment, you'll become a very problematic lawyer much later on. So, and it's really puzzling that the first Trinity Western decision was not even present in the Supreme Court decision, except for the separate opinion of the former Chief Justice, right? And so it's very, if that answer, the lack of empirical evidence should be able, if that answer was good enough for teachers in the first Trinity Western case, I don't know how that is any different for lawyers, right? The second is that some people think that, religious students can just go to secular law schools. And I think religious schools have been around for a long time, maybe more so in the U.S. compared to here. But I think they do offer something distinctive, as the Supreme Court itself has already acknowledged. And in a liberal, pluralistic society as ours, we don't need, it's important not only to have diverse individuals, but also diverse groups, right? We don't want the court acting as a guardian of some type of moral conformity, right? The third argument that has been advanced by some is that, the claim that accrediting Trinity Western would amount to state-sanctioned discrimination, right? So it would amount to some kind of government endorsement of this kind of practice. And so in this respect, I do find it a bit amusing that the court unironically invoked diversity in its promotion of diversity as a objective in its decision when it said that, this is a very good objective for the law societies to be promoting. But as we all know here, there's more than one kind of diversity, and the dissent already makes that clear, right? The tolerance, accommodation of difference are all very important values. They serve the public interest, and they serve the pluralism that we need here in society. I'm not so sure also that just accrediting this law school is a matter of state endorsement. So for example, we all pay taxes, and these taxes all go to all sorts of things that we don't necessarily agree with. And we don't, I don't think our payment of taxes essentially amount to some kind of endorsement of what the Canadian government is doing. And then finally, I just wanted to tie that with the Masterpiece Cakeshop because Brian already mentioned this. So on the one hand, you have that here in Canada. In Masterpiece, so the conventional take in the Masterpiece Cakeshop case was that it was decided on a bit of a technicality and that the baker won. But I don't think it's a technicality. It's not a technicality for state officials to who have no business deciding what sort of religious beliefs are not very palatable or despicable or hypocritical. And so everybody's entitled to have an impartial tribunal to decide their case. So I don't think that's a technicality. And the Baker did not win because one of the reasons why I have these notes is because I wanted to read from what Justice Anthony Kennedy said, that religious and philosophical objections do not allow business owners and actors in the economy and in society to deny protected persons equal access to goods and services, right? So I think it's very important that that statement is there, which is basically the Supreme Court affirmed the precedent of a case called Picky Park, which was a civil rights era case. And here, so I think it's very important that that statement is there because I'm really a lot less sympathetic to this claim that commercial businesses or any sort of business that holds itself open to the public can engage in this kind of discrimination. But on an everyday living, in normal human relation level, there is there's something to say, something to be said about the position of the baker, Jack Phillips, right? Because on the one hand, there are other bakers, if you want to buy a wedding cake, surely you don't want to have anything to do with this kind of person who doesn't want to have anything to do with you. But at the end of the day, there has to be some possibility that both sides in this debate for religious freedom and equality, there has to be some type of bargain for both of them to come together, right? Because otherwise, how can we coexist? This kind of bargain, I think, is very important to note, is that this is beyond the institutional capacity of courts to do, right? We place so much hope in the courts to resolve our deepest differences, our deepest disagreements, and I think we're missing the more important point that courts are perhaps not the best place for these kinds of conflicts. Courts can't learn the kinds of interests, the deepest, most important interests that are important to both sides, and they can't draw the kind of arbitrary lines that are necessary to resolve these kinds of conflicts. And so, before we start talking to one another, we need to stop characterizing the other side as evil. Right? And so I think the U.S. Supreme Court's modest opinion in this respect is valuable because it reminds us to do that there's a limit to what the courts can do, and it's really up to us to settle things and prompt us to engage in some kind of dialogue and discussion without having to resort to litigation. And I think that's the biggest difference between, if you compare the decision of the U.S. Supreme Court here in Masterpiece Cakeshop and the Canadian Supreme Court in the Trinity Western case, the biggest, I think, is that there's a lot more room. Perhaps there's many explanations for this, but there's a lot more room for people to bargain in the shadow of these decisions in the case of the U.S. Supreme Court as opposed to the Canadian one, because I guess here in Canada, I'm not from Canada, so this is a bit of an outsider's view. Here in Canada, there's a bit more consensus on what we think is right here on a societal level, right? The culture wars that is present in the United States, I'm not saying that it's necessarily good, but the culture wars there is not as pronounced here in Canada. And so I think that's the biggest difference. The court actually opens room, leaves out some space for the parties to engage in one another, whereas the Trinity Western decision really, I think, closes the door on so many things in these kinds of issues. So I'll stop with that. Thank you. Thank you.
Thank you, Professor Su. Before I hand it over to Adam, I mentioned in my introduction that the Trinity Western case, there's a lot of moving parts, and one of the moving parts that I forgot to mention, I apologize, was one that Anna alluded to, is the fact that Trinity Western in 2001 was also at the Supreme Court Trinity Western number 1. That case involved their teacher training program, and it revolved essentially around the same clause in their code of conduct, the sexual intimacy clause in marriage. The difference, I guess, there are differences between the cases, but I guess the focus in that case was what Trinity Western's graduates would be like in the classroom once they were teachers. And the court rejected the claim of that there would be basically found that it was speculative without any evidence to the contrary that they would be discriminatory in the classroom, and said they could have their teacher training program even though they had that clause in their code of conduct. The main difference, I guess, in the law school case was that the focus was not so much on, really at all, on what the lawyers would be like once they were in the profession, and Anna spoke a little bit about that. It was more about actually being able to attend the program, to study at Trinity Western. So, but just wanted to give that nuance, that Trinity had been to the Supreme Court before in relation to its code of conduct, the very same clause, but just on it with a different program. And with that, I will hand it over to Adam. So thank you, Anna, again, and we'll press on.
Thank you, Brian, and thank you, Anna, and thank you to Runnymede for having me. And I just want to point out that Joanna Barron knows me so well that she understands the only way to get me to a conference on a Saturday before 10 o'clock in the morning is to put me on the panel. And so I want to commend you for your insight, Joanna. A couple of disclaimers and prefatory remarks. The first is that, as Brian said, I'm a lawyer in private practice. I have numerous clients, and I'm here speaking for none of them. One of those clients is the Canadian Constitution Foundation. I think it'll be obvious that I'm not speaking for the CCF in just a couple of seconds here. And so I want to thank Howard and the team for both entrusting me with your representation and for doing so in a manner that recognizes that we don't agree on everything and that we can respectfully disagree about important issues while pursuing common objectives in the litigation process. I think that's an important thing for lawyers to be able to do with and for their clients. The other thing I want to acknowledge is that, as Anna said, the stakes, or as Anna alluded to, the stakes in this debate are not, I think, as high as they are often framed to be. This is one of those issues where each side has ready recourse to a slippery slope argument, and both slopes lead inexorably to Adolf Hitler. And I don't think that's right. I don't think it's helpful either to those of us who agree with the way things shook out in the Trinity Western case and those who feel that it's an unbridled assault on religious freedom. Some of the rhetoric around these issues is not helpful to their constructive resolution. And so to the extent that I verge into slippery slope reasoning today, I want to apologize in advance. That's just me being a lawyer. The other thing to recognize here is that we have to know what we're talking about here. So in the Trinity Western case, I think it's important to distinguish the policy outcome that was achieved by the law society decision-making that was at issue in the litigation and the outcome of the litigation. If I were a bencher, and I've gone back and forth on this issue, I should concede over time. If I were a bencher here in Ontario or in BC or in Nova Scotia, my initial instinct would have been to vote not to accredit Trinity Western. On reflection, though, I think I probably would have voted to accredit Trinity Western for two reasons. The first is that I don't think this whole fight was frankly worth it when I think the free market is going to do what it's going to do to Trinity Western's law graduates, and I say that with the greatest of respect. And I further don't think, the second reason I should say, is because I think if the law societies had accredited Trinity Western University as they were asked to do, there'd be a much more interesting legal question that would have made it into the courts, which is not the Section 2A issue, but the Section 15 issue. And this is to Anna's point about whether or not it is state-sanctioned discrimination. And this is going to be something I'll return to, but in my view, that has to be part of the analysis when we look at the Trinity Western decision, that in the backdrop, whatever the law society had decided, the two law societies that went to the Supreme Court anyway, they would have ended up in the Supreme Court regardless. It's just a question of which charter right would have been limited or said to have been limited by the decision at issue. And I'll draw a distinction in a couple of minutes between charter litigation and charter practice that I think bears on that point. In my view, neither Trinity Western nor Masterpiece Cakeshop signals any significant departure, evolution, or change in the law of religious freedom in either Canada or the United States. I think that we are arriving at a point where other laws have changed in both countries. Our understanding of the rights of individuals in both societies have changed, such that there are now conflicts between, as Howard says, majority religious views and other minority views or the minority identities of individuals in a society and the legal protections they are accorded that force us to reckon with the limits of religious freedom in a way we haven't had to reckon with them before. But in my submission, religious freedom has never been an unlimited right. So if there's one proposition I can leave you with this morning, it's that either we accept the view that the 2A right, the guarantee of freedom of religion, has no internal limits, and Section 1 has to do all the work in its case as soon as someone invokes any kind of belief or practice that has a plausible nexus with religion, or we accept the view that there are internal limits on the Section 2A right. Freedom of religion is not a set of magic words that can justify any practice and immunize it from any sort of state control. If you accept the latter proposition, that there are internal limits on the Section 2A right, then it all becomes a line drawing exercise. And the question is at what point do we say you may go this far with your invocation of religious freedom, but no further? And to the point that the law hasn't really changed that much in this regard, Masterpiece Cakeshop effectively takes that view in relying on the Piggy Park decision, which, as Anna says, is a 1968 decision of the U.S. Supreme Court. The majority of the justices on the United States Supreme Court held in Masterpiece Cakeshop that a law of general applicability that safeguards individuals from protected groups against discrimination in the workplace cannot be departed from, cannot be exempted on the basis of the invocation of religion. In Piggy Park, the litigant, Mr. Nelson, ran a barbecue joint and he claimed that his refusal to serve black customers in contravention of the 1964 Civil Rights Act was justified by a religious conviction that thou shalt not serve barbecue to black people. And the Supreme Court rejected that decision, and it was right to do so. And similarly, it is open to a court to determine that you can't say that your code of belief, even if your code of belief, I should say, says thou shalt not serve cake to gay people or barbecue to gay people or let gay people into your law school, that doesn't cut it. And ultimately, we all need to live under the same set of laws. And so your invocation of religious freedom does not justify that practice to the exclusion of laws of general applicability. The difference between Piggy Park and Masterpiece Cakeshop and the Trinity Western case is that Trinity Western is exempt from the otherwise applicable anti-discrimination laws in the province of British Columbia. So the question really in Trinity Western, I say, is whether or not the Law Society's decision not to accredit Trinity Western based on its interpretation of the Legal Professions Act in BC is an applicable provincial law that functions the way that an anti-discrimination law otherwise would, or whether, because of that legislative exemption from anti-discrimination law, it was not open to the Law Society to enact the policy that it did. There's also a consideration about the referendum in BC, which I'm not going to get into because it's frankly not that interesting, and if you have questions about it, we can talk about it. But ultimately, that question of whether or not the Law Society could have enacted the rule that it did in deciding the Trinity Western question the way it did, and whether that is the functional equivalent of an anti-discrimination law that under U.S. or Canadian law, I say, would not have allowed Trinity Western to discriminate on the basis of sexual orientation. That ultimately is a question of administrative law, not a question of religious freedom or even of the Charter. So to the extent that I was asked to defend the majority view the majority opinion, I should say, in the Trinity Western case, I too have to disappoint the organizers because I kind of think it confuses the issue. It makes too much of Charter values, to which the court did not need to find recourse. Ultimately, the question is only whether or not the Law Society had the legal authority to enact the decision that it did, and that question can be answered using the ordinary tools of statutory interpretation, determining whether or not the discretion conferred upon the Law Societies by the legislatures in the two provinces extends as far as the Law Societies carried them. It's an ordinary question of administrative law. And we can get into the administrative question, but it's beyond the scope of the religious freedom issue. I just want to flag that as this not actually being nearly as exciting as the headlines might otherwise suggest. With respect to the limits on religious freedom, I think the difficulty that we face and that the advocates of religious freedom face, and that those of us who say there should be constitutional limits or limits that are constitutional on religious freedom, is that there has to be some principled way to distinguish religious practice and religious belief from religious pretext. And I acknowledge Anna's point that it's not court's business to do so. I say there's no other way around it. If you accept the proposition that I've advanced, that religious freedom is not a right of unlimited scope, then someone has to decide the point at which an asserted religious belief or practice is not protected by the freedom of religion guaranteed by the Charter. And you cannot do that unless you are prepared to look at the evidence and say, this doesn't cut the cake, pun intended. And we, as a court, are not going to give our imprimatur to your assertion of religious freedom to the exclusion of an otherwise applicable law in this context. So to take that to the Trinity Western case, the set of reasons I actually agree with the most, although I don't agree with them entirely, are Justice Rose. Because ultimately he, at the very least, takes seriously this question of what are the limits on the religious freedom right. This is a personal view, I don't buy that an evangelical Christian is barred by their religion from studying law with a gay classmate next to them. I've never bought that argument, and I don't think you should either. And I think that the evidence before the court, this is the really important point, the evidence before any of the courts in this case doesn't substantiate the claim that that actually is what anyone at Trinity Western believed. Nobody argued that religion required Trinity Western to exclude gay people from its law school, which is what the impugned provision of the covenant did. Nobody argued that it was a religious practice. The argument was, we have these religious convictions, we have these religious practices, and we want to study in an environment that conforms to what we say matches those religious convictions. But you know what? If you truly wanted to have an evangelical law school where everybody buys into the basic premise of that law school, you have to exclude Jews. I wouldn't be able to go to that law school for two reasons. And that, to me, the fact that there is that decision that's been made there is what a court is entitled to look at to say, this isn't a religious practice, it isn't religious belief. This, on the record before us, looks like pretext, and we as a court are empowered to say so. I accept that that's a controversial proposition, but I say it does not, even if you don't agree with me that there are limits on the two-way right, at the very least, it helps us to distinguish the core of the right from its periphery. The last point I want to make is, and this responds to a certain extent to Anna, but also to the dissenting reasons in the Trinity Western case of Justices Brown and Cote, or Cote and Brown, excuse me. The argument is made that the majority erred or shouldn't have invoked charter values as a means of explaining what the balance was that the Law Society had to strike. And I agree with that. I think charter values have a role in litigation. I think they have less of a role than some members of the Supreme Court think they do, but you're going to hear about that on the next panel. I think, though, in this case, despite the fact that the right that was limited by the Law Society's decision was the Section 2A right of the students at Trinity Western or the members of that community, and we can get into whether Trinity Western itself has 2A rights that it can invoke in the discussion. In the back of the Law Society's mind, as a state actor, is the obligation to balance that right off of its concomitant obligation not to infringe the Section 15 right in a manner that couldn't be justified under Section 1. Just because you make a decision that infringes one right doesn't mean you aren't making that decision in light of the fact that making the contrary decision would have infringed another. And so the question that none of the judges wrestle with in the Supreme Court in Trinity Western is that balance. They didn't wrestle with it in the first Trinity Western case because they said the rights don't actually overlap here, and they kind of defined the problem out of existence, and they didn't wrestle with it in this case. And this is why I say as a bencher, I would have voted to accredit Trinity Western. That's the really hard question, is how do you adjudicate that conflict of rights? It existed in this case, not in the decision of the Supreme Court of Canada or any of the courts, but in the decision of the Law Society, and it didn't come up in the litigation, and I say it should have. So I'll leave it there.
Well, thank you very much, Adam and Anna. Before this is a blessing, we have a lot of time for questions. I have questions that I can put forward, but I'm sure there are questions in the room. So please, if you have questions, I don't want to hold the kind of question period hostage. I want to make sure that we have as many questions asked as possible. So I'll give you some time to make your way up there. But I just wanted to thank Anna and Adam again. Maybe one thing I'll start off with, just maybe to get your comments on. I think maybe it's more obvious or kind of at the surface in the Masterpiece Cakeshop case is how much, I wonder if we have, you were talking a lot about religious belief, religious practice, religious pretext, Adam. And I wonder how much, I think, with Jack Phillips, the baker in Colorado, it seemed pretty clear from the record that his primary reason for refusing, his exclusive reason, to my knowledge, was a view of what marriage is and what it is not. Obviously, he views it as a spousal union as one man and one woman and only that. I'm sure he has views on what is moral and immoral sexual intimacy as well, both between unmarried, whether it's heterosexual, LGBTQ, on all fronts. But there's no, seems, debate in terms of the evidence that he had no problem serving the couple in terms of selling them brownies or whatever other baked good. It was just the cake, the wedding cake, that he couldn't do. And perhaps it's even clearer, I think, in the upcoming or still ongoing case of the florist in Washington State, Baronelle Stutzman. She had served this particular couple, or at least one of the members of the couple, for years. She was a regular customer and had done birthday parties and flowers for all these events. But it was when the customer said, listen, my partner and I, who you know of, because you've served me for 8 years, we were getting married. And she said, she thought about it and said, I can't do it because of a view of marriage. The point I'm trying to make here is, I wonder how much, I don't think there's evidence of a refusal to associate generally, or to, even if, it would perhaps be peculiar if Jack Phillips had said, listen, the reason I'm not doing this cake is because of my views on sexual intimacy, because how is selling brownies or even a wedding cake for that matter necessarily, would that manifest that view? Whereas with marriage, if the view is primarily about marriage, perhaps it makes a bit more sense. Andrew Koppelman, a professor in the U.S., who has written a lot on LGBTQ issues, has said, listen, these people, he's quite sympathetic towards them, towards Stutzman, and Phillips said, listen, they're not homophobic bigots who want to harm or hurt gay people. So I guess what I'm trying to ask is, I wonder have we missed a little bit, to a certain extent, maybe have courts missed a little bit what the focus of the inspiration for the refusal is, and does that make a difference at all between being more focused on a vision of marriage versus sexual intimacy? I know these are all a bit unreflected, but I'm just wondering if we've missed a little bit. It's more obvious, I think, in the Masterpiece Cakeshop than perhaps Trinity, but it's there in Trinity as well, because marriage is referred to in the clause that was at issue. So, as you wish.
So you're absolutely right, Brian. This is going to be a big area of disagreement. It's a disagreement in Masterpiece Cakeshop where you have Justice Gorsuch and Justice Alito saying that the cake in question was not there was no discrimination because it was a matter of expression, and the customer, it wasn't the customer that was being refused service, it was the cake that was being refused service. By contrast, you had Justice Kagan and Justice Breyer essentially saying, who else would want a gay wedding cake? Which is the view I agree with. I think that drawing that distinction, and I should say before I give you my view, the UK Supreme Court recently took this up in a case called Lee and Asher's Bakery, Asher's Baking Company, a 2018 decision of the UK Supreme Court, in which Lady Hale, and the case was under reserve when Masterpiece Cakeshop came out. In the facts of the Asher's case, briefly stated, are that there was a cake bakery in Northern Ireland. There was a gay customer of that cake bakery who went to the cake bakery, who ran an LGBT organization. And during the period at which gay marriage was a political issue in Northern Ireland, this customer went to the bakery, of which he had been a customer for many years, and said, I'd like you to bake this cake that says support gay marriage. It wasn't a gay wedding cake, it was a support gay marriage cake. And the bakery ultimately said, we're sorry, we disagree with that message, we're not gonna sell you this cake, here's your money back. They were apologetic, they're sort of the perfect plaintiffs in a lot of ways. And the UK Supreme Court ultimately says this individual was not denied service because he was gay. He was denied service because he wanted a cake that said support gay marriage, and it was the expression of that political view, that particular message, that the bakery was entitled to discriminate on the basis of, despite the applicable non-discrimination law. And what Lady Hale says about Masterpiece Bakery at paragraph 62 of her reasons is the important message from the Masterpiece Bakery case, Masterpiece Bakery, Masterpiece Cakeshop, a typo in the Supreme Court reasons, is that there is a clear distinction between refusing to produce a cake conveying a particular message for any customer who wants such a cake, and refusing to produce a cake for the particular customer who wants it because of that customer's characteristics. One can debate which side of the line particular factual scenarios fall, but in our case, there can be no doubt. And so what I say is, I actually am comfortable drawing the distinction between I'm not going to make a cake that says support gay marriage, and on the one hand, and on the other hand saying I'm not going to make a gay wedding cake, because as Justices Kagan and Breyer ask in Masterpiece Cakeshop, unless there's a bunch of straight people out there ordering gay wedding cakes for I don't know what reason, there's a pretty, it doesn't mean that what is being condemned in that case is not the individual. This is not to say that a baker who refuses to bake a gay wedding cake hates gay people, is a virulent homophobe, is out to get gay people. It's that that particular act is discriminating on the basis of sexual orientation. I think we have to be comfortable drawing that distinction, and I think both Masterpiece Cakeshop and Trinity Western and the UK case leave space to do so.
Sure. We'll look at the questions. This is wonderful. A wonderful lineup, and we'll get right to it. Please, go ahead.
With thanks to the panel, a question from outside the perspective of the judge-lawyer system, so to speak. Just to continue the unbundling that you were beginning to undertake there, where I guess you try to constrain the law to the case, as opposed to generalizing the case to the law. You began to talk about the difference between behavior and the individual, right? I mean, is this, for example, if a black person shows up for barbecue, no matter what else one might, they're black in all respects of their conduct. Whereas I guess the controversy around sexual identity is also a question about behavior as opposed to straight identity. What I didn't hear in the talk was a constraint of the case between process and ruling. I think lawyers and judges are often interested in what the eventual ruling was, but the point of some of these cases seems to be process as punishment and the cost of the process. So I don't know how you would address that from a practical standpoint. And the other one is the constraint of denying service as opposed to denying access. So going back to that 1968 law, is there a problem there in saying that one person declining to provide service in presumably a fairly full market is tantamount to denying access?
We want to take a couple of questions.
Yeah, let's keep the questions going. Yeah. We'll gather up some questions and then we'll have some responses. Thank you for that.
Okay, well, my first question kind of hitchhikes on the previous question. I'm not a lawyer, I'm an economist. And it's my understanding that Professor Epstein has made an argument that when courts and lawyers consider cases of discrimination that they ought to take the role of competition into account, which I think has some resonance with the previous question. My second question has to do with subsequent events that I'd like a prediction from the panelists. It's my understanding that Trinity Western has changed its policy with respect to the covenant subsequent to these decisions. And my request is to, if the panelists could make a prediction as to whether the relevant law societies, bar associations, will change their minds as a result of this change in policy.
Thank you very much. We'll take one more question, and with those we'll get some answers, and then go back to gather more.
Awesome. So the first thing I just wanted to quickly say is I think it's important when discussing the Trinity Western situation is to differentiate. I don't believe that they were actually trying to prevent LGBTQ2 people from attending the university. There was evidence that a significant number of LGBTQ2 individuals were at the university, and I also don't think you can delineate between that community and Christians. There are many individuals who hold that identity and are also Christian. So I just felt like that was an unfair characterization. The two questions, I'm just gonna cheat because someone else asked two questions. The first is I interned for one of the lawyers who was intervening in the TWU decision, and one of his concerns is with the fact that the court has now defaulted to the Dore analysis. He feels like it's not as robust in terms of actually evaluating whether there was a consideration of a fair consideration of both parties' charter rights. So that was my first question. And my second question is this same lawyer is also working on the Christian Medical and Dental Society versus the College of Physicians and Surgeons of Ontario, that case. And there is concern that because of the way the court has characterized and addressed the situation with TWU, that now it is going to exclude doctors who are conscientious objectors. And I would say the way that the trial court has handled the issue is essentially saying that if you are a Christian or religious doctor, you can just go to a practice that doesn't involve abortion or end-of-life care, which I would say is a little bit of a victim-blaming approach, but that's what the trial court has said. So I'm just wondering if you could comment on that as well. Thank you.
Thank you very much. Anna, Adam.
I didn't get quite so much the first question. The difference between access and service, is that what was the person? Oh. Oh, right. Yeah, no, so basically I agree with a lot of what Adam said when it comes to, I don't really think that Masterpiece, for me, Masterpiece Cakeshop was much of it's not as big, it's not as difficult a question as other similar cases. Again, for me, the fact that it's a commercial entity sort of, and does a lot of the work in terms of resolving that case. And I agree with you. I think if you prevent this equation between access and service, I do think that once you deny one, you're effectively denying the other. And the other one on the Trinity Western prediction, I think there is some, if you just go by the ruling of the Supreme Court, I do think that once you remove the mandatory covenant, I think there's a pretty good case of the law school being accredited. Again, partly also because of, there's, as somebody mentioned, there's also a lot of LGBTQ students who also happen to identify as Christian who are already studying in the Trinity Western University, like the undergraduate institution at the moment, right? And so without that covenant, I mean, in case this thing comes up, I hope it doesn't. I think then I don't think that's going to be. I don't think this decision will be an obstacle for an accreditation for a future TWU law school. The Dory question, I agree with you, but I think we have an entire panel on it this afternoon, showing how problematic that whole framework is. I don't want to go into a con law rant here on the Dory case. And then finally, on the objection, the Christian doctors, I've heard of those concerns as a result of the TWU ruling, and as well as the ruling. This was 2018 as well, like the case of the Christian doctors. But I think in that case, it's not necessarily conscientious objection, which was struck down by the Superior Court, but the mandatory referral. So doctors can still. Doctors can still object. I mean, I guess the referral and the objection, I think, are two different things. And right, I mean, perhaps we need to come up with like some more principled guidelines on how to, draw the line. Like, is the act of referral the same as essentially a circumvention of that conscientious objection? Which I don't think that's the case, but perhaps that's another separate conversation.
So those are excellent questions. So I'm going to try to run through them, and there are some overlaps, so I'll address them that way. The distinction was drawn between behavior and identity, and whether or not the covenant to Trinity Western really does raise identitarian concerns rather than behavioral ones. And the point from the third question was that really the covenant doesn't prevent gay people, LGBTQ people from attending Trinity Western. It just asks them not to, have sex outside of a heterosexual marriage, and on that basis it equally discriminates against heterosexual common law couples, and so on. This argument has been raised a great deal, and I see why it has currency. Let me tell you why I don't buy it. When Trinity Western was first in the news, I did a TV panel in which I said it's a sexual orientation, the sex is kind of the point, and was subsequently called a slut by a conservative commentator. And he didn't even comment on how I was dressed on the CBC. But I actually think that's right. I think that you cannot say, attend this school, but deny an essential part of your identity. But we're not discriminating against that identity, we're just discriminating against the behavior. It would be like saying that if the covenant said you can attend Trinity Western regardless of your religious identity, you just can't attend synagogue while you're here. You can't pray to any God other than the Christian God, and in any church that recognizes, and you cannot pray in any house of worship where Jesus Christ is not recognized as Lord and Savior. That would be equally consistent with evangelical Christian theology, to the extent it's my place to comment on that. And it would, I say, discriminate against the identities, the religious identities of prospective law students. And I say this is no different. But more importantly, those who defend the covenant and say that the Trinity Western case ought to have come out the other way have to recognize that that argument cuts both ways too. If you say this isn't discriminating against LGBT people, there's no infringement of their equality protections or their rights under whatever statutory object, then because we're discriminating against gay sex, not against gay people, by the same token, the decision of the Supreme Court doesn't discriminate on the basis of religion. It doesn't draw religious discrimination. It says you can't have a law school that doesn't allow people to have sex outside of a heterosexual marriage. Same would be true of a secular law school. They can't have that policy either. It's either one or the other. And so to invoke religious protections in order to defend the covenant, but then say the covenant doesn't actually discriminate against LGBTQ people, I say belies a fundamental contradiction that I say defeats the argument. In terms of process as punishment, that's a very good point, but I think it can apply equally to just about any kind of litigation. I mean, try getting divorced in a contested context in Canada. If ultimately this is how we adjudicate the limits of our constitutional protections, and I don't see a way around that. In terms of, to the second questioner, our economist colleague, and Richard Epstein's argument about let the free market take care of it. This is kind of what I said at the outset, that if I was a bencher, I think the market for legal services is going to deal with Trinity Western's graduates, or would have if the covenant had remained in place. But I think that's an inadequate answer to the claims of equality protection by individuals from equity-seeking groups, which is why ultimately, if the Law Society had reached the contrary decision in any of the jurisdictions, there would have been litigation. And I'm actually not sure how it would have turned out. This is a question for those who think the Supreme Court got it wrong, because in your view, the Supreme Court erred in saying that the Law Society correctly balanced the various interests that were at play, and erred in concluding that the limit on Section 2A was justified. If the Law Societies had made the opposite decision, and the Supreme Court had come to the same deferential posture and had upheld that decision, saying, yes, Trinity Western can have a law school and is accredited, and because of Dore or whatever framework, the Supreme Court says that the Law Society didn't make any reversible error in granting accreditation, would you be equally comfortable with, or would you be equally critical, I should say, of that decision? And I struggle with this myself. I think my answer is you'd have to look at the actual rights that are being protected and what the limits are, which takes you back to the question of pretext versus practice, which takes you back to the difference between Section 15 and what its internal limitations are, and Section 2A. But ultimately, in order to understand why it is that the free market is an inadequate response to systemic or other discrimination, you have to look at the fact that we have a constitution and that the free market historically does a very bad job of this. So I disagree with Professor Epstein. And on subsequent events, I agree with Anna. I think that Trinity Western will be accredited. I don't think there's any I think the dissenting opinion is wrong in saying that, well, if this is a problem, then the whole rest of the covenant is a problem. I think that's not how courts will read the majority reasons, plural, in Trinity Western, and I think Trinity Western will have a law school, and it will have students, and off we go. And finally, I won't get into the Dore issue. I have difficulty with it as well, but we'll let Mr. Justice Sawson defend it later today. And as for conscientious objectors, I think if you look at the U.S. cases and you look at the amicus briefs that were filed in the Masterpiece Cakeshop decision, conservative legal groups went out of their way to say this kind of discrimination isn't like refusing to serve a black person on the basis of a religious objection. It's like refusing to perform an abortion on the basis of religious objection. And you see this argument run throughout the debate in the United States. Everyone agrees you can't deny service to somebody on the basis of race or religion, citing a religious objection. But there's a much better argument to be made, or so it is posited, against refusing to perform a particular medical procedure or some such thing on the basis of a religious objection. And there's a scholarly debate in the U.S. about whether that's a durable distinction, a principled one. But I think in Canada, for the reasons that Anna says, I don't really think the conscientious objector litigation is going to put it squarely in issue. Although I certainly recognize, and I think everybody has to, and this is back to Howard's original point about religious freedom is more controversial than it used to be. I don't think anyone actually thinks or would argue that there's any basis for forcing an evangelical Christian obstetrician to perform an abortion. No one would make that argument. No one has made that argument. And that's not the slippery slope that is engaged here.
We have some more questions, and I see we are doing well on time, so if the comments you're hearing during this Q&A inspire more questions, feel free to come up to the mic. Please, Chris.
I want to thank both of you for your perspectives and insights on this really interesting topic. Here we are over half a year later, and I'm still given new perspectives on Trinity Western, and I'm forced to rethink of it in different ways, so I want to thank you for that. But my question is on a topic that I think after the decision, somewhat to my surprise, really kind of wasn't discussed too much, and this kind of goes to your point, Adam, regarding Section 15 and how regardless of what the Law Society had originally decided, we would have wound up at the Supreme Court considering one kind of charter right, but the concurrent charter rights that were either argued to work in favor of Trinity Western or at least said to be, and I realized that that Trinity Western itself did not raise all of these arguments in oral argument and necessarily in the written arguments, but there was an argument that was made that that freedom of expression, freedom of association, and Section 15 equality rights also operated in favor of Trinity Western, and yet the majority in the span of, I think it was 2 paragraphs, dismissed these claims and said that the factual matrix underlying any of these claims were virtually indistinguishable, which to me was a very remarkable thing to say, and that wasn't really expanded on, and that really hasn't been touched on that much since then. So I'd be interested in both of your perspectives on that.
We can take our other 2 questioners, and we'll get some answers from Anna and Adam.
All right. Mine's a little bit of a simpler question, actually. Given the, I would argue, increasingly a-religious bent of society that we're seeing, or at the very least the perception of that in the government, do you anticipate that given the Cakeshop holding was primarily hinged on the inequitable treatment of the tribunal in Colorado, do you anticipate that those sorts of challenges arising more and more frequently going forward in the sort of sense of almost an administrative inequality as far as tribunals go towards religious people in the future? Thank you.
Thank you. And Professor Newman.
Thank you to both of you for your contributions. I want to hone in on the reference to Justice Rowe's opinion in the case. And I would suggest that there's a fascinating element to Justice Rowe's opinion, and there's a problematic element to Justice Rowe's opinion. And I'm quite surprised because Adam has skipped over the fascinating part and has affirmed the problematic part, or I'm going to suggest. So the fascinating part is actually his focus in on the idea of proportionality, I think. And I think in a way he signals a little bit of the concern that might be at the court that we saw also in the dissent yesterday in Frank, that there's something gone wrong with proportionality analysis and the interaction with rights. And so I'd be interested in your thoughts on that part of the Rowe opinion. But the part that I think is problematic is the idea of focusing in on religious requirements. And in your comments today, you said that we need to think about what's required by religion, or you used that word. I don't know if that's what you meant for sure, but that seems a very problematic part to what Rowe focuses on, and the majority does in its own implicit way, although not as forthrightly as Rowe does. But that's an approach that would take away from a lot of religious freedom claims that have succeeded in the Canadian courts in the past. So it's inconsistent with vast bodies of precedent. It's also inconsistent with the view of most religious freedom scholars around the world that we need to get away from that kind of focus on the requirements of religion because it would really restrict what can be protected under religious freedom. So I'd be interested in your reactions to that.
Thank you.
Answer first?
Sure. All right. So, excellent questions. Thank you to all 3. So, to take them in reverse order, Professor Newman, I agree with you that what Justice Rowe says about the interaction between Section 1 and the rights that are protected by the other provisions of the Charter is fascinating and important. I also agree that it's echoed in the dissenting reasons yesterday in Frank. I also agree that that debate is not going away, both given the current composition of the court and some of the other cases that are working its way toward it. I said at the outset that my basic proposition is that rights have internal limits. That is, in some ways, inconsistent with the way that charter adjudication has been practiced by our Supreme Court since the late 80s at least. And the work has been left to Section 1 in almost every case to determine whether or not a limitation imposed by legislation is reasonable and demonstrably justified, rather than saying, is this actually protected at the core of the right? That's different from the United States, where they don't have a Section 1, and they have to do the work of delimiting rights using the text of the rights and the various other interpretive tools that they have. The consequence in Canada of not doing that work is that we have, I would say, an impoverished body of jurisprudence and even scholarship about constitutional interpretation and the various philosophical and methodological approaches that might be taken to interpreting the provisions of the Charter itself, rather than just letting proportionality do all the work under Section 1. And I think that that is inconsistent with having a written constitution and is something that ought to change. And everything I've just said is, and I'm speaking without instructions here, is consistent with what the CCF is going to seek to argue in the appeal from the Toronto election litigation here in Ontario, where I'll have the privilege of representing the CCF. Essentially, if you think that religious freedom can't be limited internally, and that any assertion of a religious interest as a constitutional protection is sufficient for the purposes of Section 2A, and Section 1 has to do all the work, then you have to agree with Justice Bellababa at first instance in the Toronto election case, because that's essentially what Justice Bellababa does with Section 2B, and puts everything into it and leaves the whole thing to Section 1, and look what happens. So I think that will continue to be a difficult issue, and I think that is something that's important in Justice Rowe's reasons. With respect to the issue of requirements, I struggle with this. On the one hand, I see and understand and appreciate the objection to limiting the protection of religious freedom to that which is required. I also agree that doing so is inconsistent with everything the court had said previously in the cases that you're referring to, Professor Newman, about what it is that Section 2A protects. And I think ultimately that isn't a bright line rule. It can't possibly be a bright line rule for the reason that Anna says. We should be uncomfortable with courts doing theology, deciding what is required and what isn't required. And there's a vein of that reasoning that runs through the Highwood congregation decision that came roughly around the same time as Trinity Western, about which I'll say no more because my colleagues acted in it. But the issue of whether or not a court can say what is required and what isn't is a fraught one, and it should be. But I do think that without setting a bright line rule, there has to be some space to say, where I disagree with Justice Rowe. Justice Rowe looks at the second step of the test for what is protected under Section 2A and says that the asserted rights claim in this case fails at that stage. He accepts, for the purposes of his reasons at least, although he throws some cold water on it, that the belief or practice at issue has a nexus with religion. It's that question of what is a nexus with religion in that Syndicat Northcrest, where that language comes from. What is sufficient to constitute a nexus with religion that I think is the difficult question under the Canadian jurisprudential framework. Deciding whether or not a mere assertion of a connection with religion is sufficient for a nexus versus whether you need something deeper. Whether you can do that without going all the way to saying what does the theological principle require or not is for bigger brains than mine. But I do think that that's what, as a lawyer, I look at and say that's where the issue is going to be, is we have to understand what that nexus means and what that requirement shakes out to in practice. I'll swing through the others and then let Anna say more about them. In terms of the increasingly a-religious bent of society and whether we're going to see more arguments of basically bias, the way that Masterpiece Cakeshop was decided, I'm not sure that I accept the empirical premise of the question, but to the extent that we accept it arguendo, I think that in the United States, certainly, that will be something that lawyers will be keenly aware of, is any hint of anti-religious animus, and whether that is a basis for overturning a decision in the administrative context. I mean, that goes all the way back to, oh God, I always butcher the name, the city of Hialeah case. It's a Lukumi Babalu, which goes back to like the 80s or 90s, I think, or, yeah, which is also a decision of Justice Kennedy, where this question of anti-religious animus being a sufficient basis to upset a decision is established in the U.S. law. I think that hasn't, again, this is why I say Masterpiece Cakeshop didn't change all that much. In Canada, we have consolidated Bathurst and other cases that deal with institutional bias in the administrative context, and they will continue to govern those sorts of claims. I'm not persuaded we're going to see more of them, though. In terms of Trinity Western's other arguments, I think that's a completely fair objection. I teach a course in appellate litigation, and one thing that we ask judges who come and speak to our students is, when do you feel comfortable not dealing with an argument that was fairly and fully raised and argued by the parties? There's a procedural fairness issue, I think, that one can say, in dismissing an argument offhand the way that the majority, well, everybody did, in the Trinity Western case, or ducking an issue like the associational rights of Trinity Western or the collective religious entitlements that Trinity Western might have asserted in the litigation. Ultimately, you know, I'm sympathetic to the view that the Supreme Court didn't want to issue a 500-page opinion, and if they dealt fully with absolutely every argument, they never would have been finished. The real question I think you have to ask is whether or not the case was fully disposed of, and whether they had a sufficient basis to answer the litigation question that was posed to them. And I think there are good arguments on both sides, although I confess I'm not all that troubled about the way the Supreme Court dismissed those cases based on the record that was before it.
So I'm sympathetic to Adam's position that there has been a lot of, the Supreme Court has become, for lack of a better word, lazy in terms of relying
I didn't say that, just for the record.
Okay, sorry.
I have to appear in front of these people.
All right, that's true. I don't have to appear, so I can say it. So I do think the Supreme Court has become lazy in terms of letting Section 1 and the justification analysis do all the work, and that's partly tied to why they didn't answer. I mean, that's why it was also problematic for me that they didn't answer all of the other issues that was posed before them, the speech, association, and the equality issue. I mean, again, maybe there might be good reasons for it, but the Supreme Court, I think, missed an opportunity to develop the internal limits. Like, what do these rights actually mean in the Canadian context? So, for example, just to extend the freedom of association for a long time, I think this has been largely limited to the labor context here in Canada. But surely that's not the only kind of association that the Charter intends to protect. And that partly has to do with this whole, again, going to this whole, like, what is required, what is not required in terms of freedom of religion, the substantive limitations, the substantive principles underlying freedom of religion. I think Canada has, for the most part, followed the trend of basically just accepting whatever the claimant says is part of his or her religion. Right? So in other places around the world, very few places, but there are places around the world where there is a distinction between what is an essential part of your religion, what is something that is peripheral. Right? But in the United States, in Europe, Canada, all of these Western societies have basically adopted this idea that it's a very subjective issue, right? And so absent any sort of fraudulent claim that, you know, for instance, you come up with a church of marijuana because you wanted to, I guess not here in Canada, but I mean in the U.S., if you wanted to smoke weed, for example, and you set up a church that somehow involves smoking weed, then probably that's not going to fly with the court, but it's not going to be. But absent those kinds of extreme cases, it's not going to be, the court is going to be very permissive with what passes off as a religious claim, right? And so it's, I mean, I understand that there's been some problems to it, but I think I would rather err on the side of giving as much freedom to religious communities in defining the own tenets of their own religion. Finally, just on the animus question, I think after this case, after the Masterpiece case, definitely most state actors would be very conscientious of what happens during the initial proceedings so that it doesn't become a reason for the court to strike down whatever their decision is or to strike down for some type of unconstitutionality. But I just wanted to flag that it was not in the Trump, in the Muslim ban case, that was sort of one of the arguments that was advanced by the lawyers there, and they were, the court did not really even, I think they were given all the tweets that the president made in support of that ban, and the court did not really give that any kind of consideration. And so a lot of scholars or observers were quite surprised with the results, at least on that animus question. But then maybe that's also a very unique situation.
Wonderful. I think we have another batch of questions that we can take up. This might be our last batch, but we're still doing well on time. So if there's more questions, let's see if we can fit you in. Gerard.
Well, thank you very much, both of you, for coming out this morning. My question is something you've both alluded to but haven't really dug your teeth into, and the Supreme Court didn't really deal with it in either TW or Loyola, and that's the extent to which an organization or a corporation can actually have religious freedom rights. I think this issue isn't going away. It's come up in the United States and I think led to some, what I would submit are strange results when you hold that what seems like just a typical business has religious freedom rights. But at the other end of the spectrum, if you look at a particular congregation, Christian, Jewish, Muslim, any religious congregation, if you say it doesn't have religious freedom rights and only the individuals do, frequently you find situations where you don't really seem to get at the wrong that has gone on to the community as such. So this issue likely isn't going away. What do you think will and should happen? If you think a religious freedom could apply to a corporation, how do you determine where to draw the line? And if not, how do you distinguish that from Section 2B, freedom of expression, where it seems to be settled that a corporation has freedom of expression rights? Thank you.
Asher, did you have a question? Okay, we'll gather as a batch and we'll come on up.
Do you want me to ask
Yes.
my question? No.
Yeah,
Okay.
that's right. Yeah.
All right. Well, again, thank you both. First of all, I just want to clarify, I've never owned a bakery in the United Kingdom. Adam gets the joke. That's all that matters. So my question's for you, Adam. I agree with what you're saying about that the main issue in Trinity Western that I think the majority really didn't answer was the statutory interpretation, the jurisdiction of what the Law Society could do. Had the Law Society found that it can't go there, that human rights legislation didn't apply to the university, therefore it needed to accredit because Trinity Western was an otherwise competent institution, you indicated that that would have led to a Section 15 application, which probably it would have. Now, would you concede that that kind of application probably wouldn't be successful or shouldn't be successful? Because the way I see it, there's a huge difference between the state discriminating versus the state allowing a private actor to discriminate. Typically, we don't find that the latter would engage the charter. Certainly, the Supreme Court has said there's no obligation, for example, for provinces to have human rights legislation. Every province could get rid of their human rights codes tomorrow. That doesn't mean they can't be under-inclusive, but they don't, as a matter of law, have to have human rights legislation. And if we go down this road where the state has an interest not only in not discriminating, but in preventing private actors from discriminating in order to not run afoul of Section 15, what kind of area do we get into with, say, religious charities or churches being tax exempt? How does that all play out? You know, is the government running afoul of Section 15 by allowing churches that are evangelical to have tax breaks? Like, where do we go, in other words, if that is sort of the law?
Thank you. There's one more question, perhaps? We'll gather that one and get some answers.
So yeah, it's a little worrying because I know this is being posted online, so let me preface it with a million asterisks and devil's advocate, so I don't want to get in trouble. But Two questions. One, more broad strokes. Is there an argument to be made for Trinity Western in terms of advocacy? And if we believe that a legal degree and a law degree is a tool for advocacy, is there some argument there that could be made to say to what degree does a institution have over or control over the type of students that they want to hand those tools over to? And I'm from an institution where certainly it's not implicit, but it's a little underhanded. Everybody sort of knows you have to pay deference to sort of a social justice agenda in order to get into the institution. At least in Trinity Western's case, it's explicit. And from an increasing number of law schools, it's more implicit that you have to sort of pay your deference to it. So I don't know if there's a difference there between a law degree and sort of a cake. And then in terms of the bakery, you mentioned that there was a difference between banning a message and banning an individual. But is it not going a little far to say that the courts need to mediate and decide which message? So I guess this is the slippery slope argument, is would we not then get sort of into a regulatory board where we have to submit the cake message beforehand and have the government approve whether or not it's the message being banned or it's the individual being banned? So anyway, those are my two.
I'm just going to answer because Adam has a longer thing to do. Okay, I'm just going to speak on the corporations question for a bit. I think, well, too bad that Chief Justice McLachlan already retired, but her concurring opinion in the Loyola case recognized that, or at least seems to recognize that there is indeed some type of corporate exercise of religious freedom. Now, I'm not saying that all corporations are the same, so perhaps for-profit corporations might be a bit different as opposed to a non-profit, like a corporation, like a hospital or a school. And so I think, churches are in a different category altogether, right? Because in most places, almost all places around the world, churches are exempt from many of these, are exempt from many kinds of statutes, non-discrimination statutes, one being one of them. But the corporations front, I think that is, again, perhaps the Supreme Court, that is another one missed opportunity to say something about whether a corporation can, a nonprofit corporation, because I think that is a bit harder. That is a more difficult question to answer. I think there's going to be a lot more litigation going forward. There is some, apart from the concurring opinion of Chief Justice McLachlan, I think there is some reticence and reluctance to recognize these kinds of corporate rights. But I agree, though, because usually the argument as to how do you distinguish that freedom of religion between freedom of religion and freedom of speech is to say that, of course, corporations can speak, but then they don't go to church, right? They don't have a soul. So that's usually the common defense for saying that, of course, corporations cannot have any kind of freedom of religion rights, but I think, and even that, even freedom of speech for corporations, I think, is not as uncontroversial that we seem to think it is. There's still a lot of pushback on that idea, and even for freedom, and more so for freedom of religion, right? And I don't have any good answers as to whether they should or they should not. I do think there is an argument to be made for them. But I'm not. I don't have a fully formed defense of whether Walmart should be able to have any religious rights under Section 2A.
So let me start there, and to Gerard's question about organizational religious freedom rights. My own view is that no, an organization does not have a religious freedom right, even if an entity like a corporation can avail itself of Section 2B. I think you can get there on the text of the Charter and the difference between expression and religion. This was the point that Anna just alluded to. But this is to my broader point about we have to do the work of interpreting these provisions in order to figure out what they protect and who they protect. Courts dodge those questions as they did in Trinity Western because our approach to constitutional interpretation invites them to do so. So change that culture in the way judges approach these questions, and I think that these sorts of things get answered. But no, I think that I take your point that there are certain claims where saying that the rights are held by the individual rather than the organization doesn't really get to the meat of the matter. My response to that is that's an awfully formalistic way of looking at those sorts of problems. I would be very surprised if you could come up with an example, and you don't have to do it right now, of a case in which the outcome would actually shake out differently and you couldn't reach the same result based on ascribing those rights to the individuals behind the corporation as opposed to the corporation itself, which is what happened in Hobby Lobby, right? The Supreme Court in the Hobby Lobby and Burwell decision, to which Gerard referred, which was decided under a statute, not under the Constitution, it was decided under the Religious Freedom Restoration Act. In Hobby Lobby, the Supreme Court ties itself into pretzels to emphasize that this was a closely held family corporation and that while Hobby Lobby is held out as a precedent for organizational religious freedom rights, I think it has to be read more narrowly than that, and that to the extent that it is an organizational case, it can be reduced back to the individuals behind the organization in that case without too much difficulty. Jump to the third question about advocacy. I know I'm in a room where there are many who feel that you have to espouse certain social justice, lefty, oatmeal, granola, motherhood, apple pie statements in order to get into and succeed at law school. I'll go on the record and say I think that's baloney. I think it's always been baloney. I think if you apply to any so-called left-leaning law faculty in the country and say that you are an evangelical Christian and you want to go to law school in order to advance that agenda through the courts, that's going to distinguish you as an applicant and probably help your application more than hurt it. And I think the perception to the contrary is not based in empirical reality. And again, feel free to prove me wrong, but I'm avoiding making eye contact with the former law school dean in the front row, but I think that the experience, if you look at any law faculty in the country, yeah, sure, maybe law professors lean to the left, but I mean, come on, how much of a snowflake are you? In terms of and back to the question of whether, though, institutions should be able to exercise discretion in the admissions process to have a certain kind of student who have a certain kind of view. So in other words, at least Trinity Western is doing this openly. Leaving aside my dispute with the facts behind the question, I don't think there's any problem with a law faculty exercising some discretion about what kind of student it wants to admit. But I don't think that denies the Law Society the role that it has in deciding that certain kinds of, the exercise of that discretion can interfere with the public interest, and the Law Society has a role in assessing that in the accreditation process. On the accreditation process, and this brings me to Asher's question, this hasn't been pointed out yet, but it's not as though if Trinity Western had kept its covenant and said, screw your accreditation, and if the law societies in BC, Ontario, and Nova Scotia, well, Nova Scotia's been struck down, but if in those provinces had said, we're going to refuse to accredit you, it's not as though those law graduates couldn't become lawyers. They could become a lawyer in Ontario or BC exactly the way that I had to become a lawyer in Ontario and BC, by passing a couple of exams and then articling like everybody else and writing the bar exam like everybody else. I think it's important to note what the stakes of accreditation are. And this is not about the Law Society shutting down Trinity Western, which is language that appears in the dissenting reasons. I think that misapprehends the facts of the matter. More importantly, the Law Society, if the Law Society, the argument is made, and Asher's question gets to this, the argument is made that the Law Society does not have the jurisdiction to regulate law schools. If it can refuse to accredit a law school because of a discriminatory policy like this, why can't it regulate a law school on the basis of its tuition being too high and the access to justice concerns that has? I'm prepared to argue that a law society could decline to accredit an institution on the basis of its tuition being too high. Whether it would or not, and whether those benchers would win re-election in the democratic process by which the legal profession governs itself under legislation passed by a democratically elected legislature, is a separate and practical matter. As a legal matter, I don't see the problem. Because ultimately, let's return to the statutes here. I sit before you as a defender of the democratic process, both the process that constituted the Ontario and BC legislatures that passed the legislation at issue, legislation that by its terms, and we can argue about on a correctness basis or a reasonableness basis about how broad that discretion is, but everyone agrees that the law societies are granted powers and discretionary powers about many things, including the accreditation of law schools under their respective constituent statutes. The legislature made that decision. It decided to trust the legal profession to regulate itself in the public interest. The legal profession are people like me, members of law societies. Benchers are democratically elected. We haven't mentioned the Catalyst paper decision in this case yet, but the Supreme Court has basically said with respect to municipal governments that where you have a provincial delegation to a representative body that's democratically accountable, the court's oversight role is very limited. So I say it should be with the Law Society, because just as, and there's some who disagree with this, just as tomorrow Queen's Park could repeal the City of Toronto Act and abolish the municipal government and be entirely within its rights under the applicable constitutional provisions, so could it repeal the Law Society and said you're not regulating yourselves anymore. But a different decision was made. And so to answer your question, Asher, you have to look at the statute. You have to interpret what powers the Law Society was given. And then, and this brings us to the standard of review, you have to decide who gets to decide what powers the Law Society was given. That issue is kind of buried in Trinity Western, I think because they knew they were about to throw the whole thing out and maybe start again. But ultimately, that's an administrative law question rather than a constitutional one. And finally, in terms of the Section 15 application, I'm not convinced that a Section 15 application in this case wouldn't succeed. I understand the argument that the Charter is a shield, not a sword, that Section 15 through the Law Society Act should not be used to impede other rights of other rights claimants under our constitutional framework. But this is also a matter of framing. If the Law Society accredited a law school with a discriminatory admissions policy, the Law Society would be using its power to decide how many accredited law school seats there are for the purposes of its credentialing jurisdiction, where those seats are, and who gets to fill them. And it would be deciding that, in this case, 60 law school seats that would entitle you to write to article and write the bar exam in Ontario without having to go through the NCA Certificate of Qualification process would not be open to LGBTQ students. That, to me, is at least passes the straight face test for making an argument of state discrimination. And I think that there's a very real likelihood that that such a challenge would have succeeded. And finally, to Asher's question about religious charities, leaving aside what might be my own policy views about whether religious organizations should enjoy charitable exemptions as a matter of tax policy, there is here too the difference between that case and the one that Trinity Western raised lies in the difference between the Law Society Act and the Income Tax Act. I think there's a much better argument to be made that a law society exercising public interest powers under a Law Society Act can make the kind of decision that was impugned here than for a statute like the Income Tax Act, whose purpose is to raise revenue for the government, to make the sort of distinction that, Asher, you're referring to. And that too would come, so in other words, that would be litigated on a different basis than this case was. Although, of course, there are going to be views to the contrary, and I acknowledge that. And since I think Brian's about to make us stop talking, let me just say how much of a privilege it is to be part of conversations like this. They don't happen enough in the Canadian legal profession. I dare say in the Canadian Legal Academy, again, avoiding Justice Sawson's gaze in the front row. And they should happen more, and I think Runnymede does phenomenal work in fostering dialogue about this, and if we can have a respectful conversation about this, so can the rest of our colleagues in our chosen line of work. So thank you for being part of it, and thank you to Runnymede for making it happen.
Well, thank you so much, Adam and Anna, for a wonderful session on religious freedom, on Trinity Western, on Masterpiece. I think one of the questioners has said that they've been thinking about these cases and are constantly, even months later, learning new things. Same applies to me, and I'm sure for many in the room. So really has been a privilege for me to moderate this, and you were both wonderful. It was also, just on a personal note, great to meet both of you. I've been looking forward to this. So please join me in thanking Adam and Anna.